Senators.
Okay, we are live, and today is February 21st. This is the Senate Health and Welfare Committee meeting, and today we're looking, we're continuing and getting toward the end of testimony on S37, an act relating to access to legally protected healthcare activity and regulation of healthcare providers. And then we'll, after our testimony, if we have time, we'll be moving into some markup with our legislative council. So first up today is our Attorney General, Charity Clark. Welcome. Thank you. Before you begin, I'm going to have the committee introduce themselves around the table so everyone knows you and you know them. So Senator Hardy, go ahead.
Hi, I'm Ruth Hardy from Addison District.
Terry Williams from Rutland.
Jenny Lyons from Chittenden Southeast.
Good morning, Dave Weeks from Rutland County.
Martine Hewlett from Chittenden Central.
Welcome. And we welcome your testimony on S37.
Well, thank you very much for having us in. We're here specifically to talk about Section 8 regarding crisis pregnancy centers, but I want to emphasize that we support the whole bill and happy to be here. We at the Attorney General's office have experience and I would say expertise in consumer law, and I like to say, because I think it's true, that probably everyone who is a true expert in consumer law in Vermont at one point worked at the Attorney General's office, because that's we have a whole unit devoted to consumer law. Before I was Attorney General, I was Chief of Staff. Before that, I was in our consumer unit. That's what I did. So this is an area that's near and dear to my heart. And it occurs to me that perhaps this committee doesn't hear a lot about the Consumer Protection Act and consumer law. So I just wanted to offer to tell you a little bit about it, if that's helpful. If you do hear about it and you're familiar, I can skip ahead.
Very brief.
Okay, this is the brief. There's two prongs of the Consumer Protection Act, which this section is modeled after, or in the spirit of. One is deception, that's the most popular. One is unfairness. Deception is very familiar to all of us because we are consumers, and when we go into the marketplace, we sort of know it when we see it. Not always, and that's part of the problem, but it's something that we encounter. So there's three elements. There is a misrepresentation. The misrepresentation is material to the consumer when they make their ultimate choice. And the third one is when that consumer, in making their choice, they are reasonable. There's a reasonableness in making their choice. It was material, there's a misrepresentation. So that's sort of the gist of consumer protection. We are troubled anytime there's misleading information out in the marketplace, because part of the Consumer Protection Act is there to protect consumers. It's also to protect the marketplace and our system of living and business in our country. So that is the basic landscape. I wanted to come personally to tell you that we are supportive and enthusiastic. This is an incredibly important issue. We're grateful to the legislature, both in the House and the Senate, who have so robustly shown commitment to this issue and supporting people who have been adversely affected by the Dobbs decision. So we wanted to come and make that statement. I wanted to come personally to make that statement, so you heard me. I do have our subject matter expert here, who is Sarah Acebes, an Assistant Attorney General in our office. I know you're tight on time, but I would like to just tag out and see if there's anything I missed that she would can address. And if you have questions, she would be probably the best person. She's delved a little more deeply into this particular bill.
So the first question I have is, will you be providing us with written testimony?
I don't believe so.
No. Okay.
Would you prefer us to provide? We can do that.
If you could, I think,
sure.
in terms of the elements of the consumer protection, and then any recommendations that you have for improving the bill.
Yeah, no
Very
problem.
useful. Yeah. Good. Okay. And Sarah, do you have something separate that you wanted to share regarding the bill itself or the language at this point? What I might ask you to do, which would be very helpful, is, and I will ask you to do that, is to send whatever information you send to connect with our legislative council.
I don't have anything to add at this time, aside from the fact that we have been working with Legislative Council on this particular section of the bill. And I think they will be able to elaborate on that more, but we are, I think, in a good place.
Okay, that's good. And we'll hear about the recommendations as we go through markup.
If I could, ma'am, just curious, given the Consumer Protection Act, if the limited services pregnancy centers have been challenged in Vermont in the past, is there a history or a record?
Not to my knowledge, although my understanding is that these centers they don't take money for their services, which is why legislation is needed, because otherwise the Consumer Protection Act would already cover any misrepresentation done.
That's very, very, thank you.
Other questions for the AG or her backup? Sarah? What is your title, Sarah? I'm sorry.
Assistant Attorney General,
Assistant Attorney General.
AG.
You should know that. Okay. Any other questions? So your predominant interest is on that section of the bill. Are there any other sections of the bill that you might have comment on that might be helpful?
I only looked at this section. I skimmed the rest of the bill to make sure that, it's at least generally sounded very good, and it did, but only offered the Section 8 testimony today.
This probably is a section that relates the greatest to your office.
Yes.
And OPR and Board of Medical Practice and others are more involved in
And
that
we,
section.
of course, want to make ourselves available because we are experts in consumer law and, can see the benefit of this section with making sure that the marketplace is fair.
Okay. Thank you. Well, we'll stay connected as we go forward.
Perfect. Thank you.
Thank you very much. Thanks, and thank you for being patient.
Oh, sure.
That's for everyone. Okay, and so we'll move on to Renee McGinnis, who reached out to offer testimony on this bill. She's a member of the Vermont Family Alliance. Renee, you are here, and we do have written testimony from you. Thank you for providing that. And so we'll follow your written testimony. Please introduce yourself for the record, and then we look forward to your testimony.
Sure. My name's Renee McGinnis from Vermont Family Alliance. We are a parental rights and minority protections advocacy group. I actually shortened. My screen sharing has been disabled. I don't know if that can be enabled because I asked to be able to screen share.
You can you are now screen sharing. You have that
Okay.
capacity.
I am not finding my document coming up. So I will just have
We
to-
do have your document in front of us.
Yeah. Okay, I have a shorter one. I'll just go with what I have. Here we go. Oops. That's not. Let's see. All right, what I'm wanting to share is not coming up. That's odd.
What we might ask is if our committee assistant can put the document up, if we have it. Which document are you asking to have put up?
It's a Word document.
What's the title of it?
Is it the shorter testimony from today?
Yeah, why don't you, if you can throw that up, that would be great.
I can do that.
Thank you. I
Mhm.
don't know why what I wanted to share is not coming up. Unfortunately, that's
Technology.
Is that coming up
Yeah.
for you?
it is. Thank you.
Perfect.
All right.
Pretty inarticulate.
So the Vermont State Legislature, we find them to be inconsistent in their pursuit of healthcare choice for individuals, free from government interference. Last year, legislators claimed that Article 22 would keep government out of decision-making between patients and their doctors. I can't even scroll. I don't know what's going on. There we go. This year, S37 and H89 proposed to codify gender-affirming care as the only type of care for minors experiencing gender dysphoria and incongruence that will be shielded from abusive litigation from other states. The only type of care that will be fully funded by insurance companies, making gender-affirming care a priority over all other types of health care, and shields practitioners from increases in malpractice premiums, while countries in Europe are now reassessing and changing their standards of care due to negative impacts of exclusively gender-affirming care. So as you know, the bill references Section 8, Act 35, which applies specifically to minors. So that makes S37 pertinent to minor protections and parental rights because it dictates care for minors. I would like you to review the submitted CAS review interim report. It's a 112-page report. I was hoping to screen share with you a graph from that report, but we'll get to that later. Hillary Cass is a pediatrician, a highly esteemed pediatrician who was appointed by the NHS England to review the Tavistock Clinic after a lawsuit against Tavistock was filed. And if you just scroll down a little bit, I want to get to the third bullet point. The study concludes in part, in bold there, the lack of discussion and consensus on treatment protocols, and skipping down to there's pressure on staff to adopt an unquestioning affirmative approach, which is at odds with the standard process of clinical assessment and diagnosis. In addition, the summary portion of the CAS review states that there's evidence on the appropriate management of children and young people with gender incongruence and dysphoria is inconclusive both nationally and internationally. The review is not able to provide definitive evidence, provide definitive advice on the use of hormone blockers and puberty blockers and hormones. And I wanted to show you the chart on page 33. I had this all set up. I don't know why it's working. Chart 33 in the CAS review interim report shows a dramatic change in the case mix from birth registered males presenting gender dysphoria in early childhood to now a very dramatic change in just recent years to birth registered females presenting in adolescence. The medical community has not provided evidence-based studies as to why. Oh, no, thank you. Yeah, there's the study. So in orange there, I had it shrunk down so you could see the whole thing because you can't see the key. I had to zoom it down to about 70 or so. But the orange there, that's the dramatic increase in adolescent girls presenting with gender dysphoria, birth registered females. So why the change in this case mix? I think that question needs to be answered before we're codifying exclusively gender affirming care. You know, I know people really do have the intent to, to reduce, to improve mental health among our youth and reduce suicidality. There's an AAP article that came out. I don't remember the year of it, and there wasn't a whole lot of time to share a whole lot in 7 minutes. But youth presenting with gender dysphoria have a much higher percentage of childhood abuse. So I think the mental issues need to be looked at before we're affirming and steering youth toward gender affirming protocols only. Let's see. Yeah, so if you could, Alex, can you go back to my written? Thank you so much. Okay, so yeah, we looked at chart 33 of the CAS review. Again, the medical community has not provided evidence-based studies as to why there is a dramatic change in the case mix. So this rush to treat birth registered females with exclusively gender-affirming treatment under a dubious, you can click on the link if you want, the New England Journal of Medicine assessment that it's the only way to improve mental health and reduce suicidality. It's as trendy as tonsillectomies, except with life-altering consequences. The World Association for Transgender Health is on version 8 of its standards of care since 1979, with a dramatic change in 2009. Let me see if I have that footnote. Okay, I have that footnote. I've got 1 minute. Yeah, that footnote on the World Professional Association for Transgender Health on version 8, which came out in 2009, it indicates on a footnote, the standards of care version 7 represents a significant departure from previous versions. Changes in this version are based upon significant cultural shifts, advances in clinical knowledge, and appreciation of the many healthcare issues that can arise for transsexual, transgender, and nonconforming people beyond hormone therapy and surgery. So again, Vermont Family Alliance is opposed to S37 due to the lack of evidence-based studies that indicate that this is the best path forward for all youth and all minors presenting with gender dysphoria and incongruence. Thank you.
Renee, thank you. I'm sorry that you've had difficulty with the technology because that always makes it difficult for your testimony, but
Sure, yeah.
we have everything here in writing. I did want to ask you a question. I mean, you opposed the bill, but it also sounds like you're questioning the diagnosis itself of gender dysphoria or incongruence. That's one question, and the question you might answer before that is, what is the organization you represent? Who are the members and how are you organized? Because I think it's a new one for us in this committee.
Yeah, Vermont Family Alliance, we are just a grassroots organization, members across the state, parents, grandparents, advocating for parental rights and minor protections.
Oh, thank you.
We believe that parents are the experts of their own children and that they always need to be at the forefront of guiding their children's healthcare choices, not the state.
Thank you.
Mhm.
So, and as we heard from one of our expert folks testifying about the issues you're concerned about with children, that parents are very much engaged in working with their kids in the process of diagnosis and treatment of gender dysphoria. So we're reassured of that. At least I am. But now I do want you to speak to the first question, because you indicated that this treatment is a trend. And I think you made the analogy of tonsillectomies in your written testimony. So what does the Vermont Family Alliance disagree that gender dysphoria is a treatable medical condition?
Oh, I definitely agree with supporting youth and minors that are experiencing gender dysphoria, and that they need help and care. These bills codify exclusively gender affirming care. As I already expressed in my testimony, countries in Europe have been down this path, and they've seen the negative effects of exclusively gender affirming care. The Dutch approach is much different than what was happening at Tavistock. Tavistock claimed to be following the Dutch approach. The Dutch approach has a lot fewer people that regret and want to detransition because they often take a lot more time. They take a year actually talking with youth that are experiencing gender dysphoria. So yeah, their models, I mean, I've studied greatly. There's too much to share in the small amount of time that I've been given, that Vermont Family Alliance has been given to testify. So our greatest concern is that some youth will actually be harmed by codifying exclusively gender affirming care.
Thank you.
Yeah.
Senator Hardy has a question.
Thank you, Madam Chair. I don't have a question, but hi, Renee. I'm glad you got a chance to
Hi,
testify.
Ruth. Yes, thank you.
Yeah.
Glad to be here.
Yeah. I do want to just say there's nothing in S37 that would prevent parents from being involved in their child's health care. That is just not part of the bill at all. Parents are still involved in all aspects of the care, just like they are now. There's nothing in the bill that prevents that.
Yes, but only if it's gender affirming. That's the problem. Only if it's gender affirming. Again, it's already proven to have caused a lot of damage and trauma to a lot of patients, particularly in the UK. The Tavistock is facing, a class action lawsuit up to, around 1,000 youth who claim that they were rushed into transgender treatments. And I hope you take that into consideration before you codify exclusively gender affirming care. And this bill does, in fact, touch on parental rights just by having the definition of the bill that you're referencing, section Title 18, right? Act 35, it touches on parental rights. Yeah, you're only supporting parental rights as long as the parents are gender affirming. And I think that there needs to be a long look with these children. Time and care needs to be taken before they're rushed to hormone blockers and gender affirming care.
All right. Well, I'm not going to argue with you about it, but there is nothing in this bill that prevents parental.
Well, thank you.
Only if they're gender affirming. It only supports parents if they're gender affirming.
Thank you, Renee. And as we go through the bill, we'll be sure that the legal language is clear. Any other questions the committee might have? All right.
Well, thank you very much for giving
No,
us
thank
time
you.
for your committee. I
Yeah, thank
appreciate
you
it.
very much for jumping in so quickly.
Thank you. All right.
All right. And so we're going to move on to OPR, and Lauren Hibbert, the Deputy Secretary of State, is here. We used to call you the Director of OPR.
You're wearing both hats today, Madam
Both
Chair.
hats today.
For the record, Lauren.
And
Hibbert.
we've all introduced ourselves, so we'll go right ahead.
Yes, for the record, Lauren Hibbert, Deputy Secretary of State. I'm going to just focus my testimony on two questions that I have received offline. One is the licensure of crisis pregnancy centers, and the second is the licensure of sonographers. I'm happy to address any other aspects of the bill, but that's sort of the general thrust of my testimony.
Yeah.
And I'll try and be brief. We obviously, or perhaps it's not obvious, we believe in the power of licensing. That's what we do. We know that it ensures public protection, and we know that with licensure, we have the ability to take away a license, and that is a powerful thing. We want to be cautious about the licensure of crisis pregnancy centers. Typically, a license gives us the impression of a state seal of approval, and that's just something that, particularly with this bill and this issue, we would encourage some caution around. We do regulate some facilities, pharmacies, funeral homes, real estate offices, several barber and cosmetology shops. We have inspectors that go into those facilities. We do not at this time regulate any health clinic or medical practice. And this would be the first instance of OPR licensing a practice. To my knowledge, there's not a structure in this state for the licensure of clinics or doctor's offices. So that's something that would be a unique carve out, not impossible, but a unique carve out. I do know in conversations that there are federal oversight of some facilities, health facilities, but as to my knowledge, not from the state level. There is regulation of the hospitals that's done by the Department of Health. And so that could be a home for the licensure of pregnancy or crisis pregnancy centers. All of those challenges taken into account, licensure at OPR is not unsurmountable. We certainly could do it. We would need some resources around it, but we could do it. And we could implement standards and a licensing structure. And if you're thinking of other regulatory homes, the Division of Licensing and Protection within the Department of Aging and Independent Living has a regulatory oversight over those facilities. And then the Department of Health, as I mentioned, with hospitals and surgery centers. And I would hesitate to think this, but there is the Certificate of Need system as well for setting up these systems. So very complicated. And the big take home from our perspective is just to, or I guess a word of caution is the licensure of a facility does give it a sort of state seal of approval. For ultrasound technicians, sonographers, we could absolutely implement and administer a sonographer license. That license would likely rely on national certifications and examinations that are currently provided by the American Registry of Diagnostic Medical Sonography. And so we would probably rely on that national certification to issue our certification or registration. And I believe I've talked about this within this committee, but we have some new members here. There's 3 different types of licensure in the state. Registration means that everybody who's doing the thing needs to be registered, but there's not particularly a set of qualifications to get the registration. A certification is people who want to say that they're certified. It's qualifications based, and they can use the certification to advertise that they are qualified to do so, but it's voluntary. And then there's licensure, which is again similar to registration, and then it's mandatory for everyone in the field, but it is qualifications based. So classic examples of registration would be home contractors, which does not have qualifications to be a home contractor, but it's mandatory for everyone in the state who is a home contractor who exceeds a threshold amount to get registered. An example of a certification is dietitians. Dietitians are certified, but anyone can give you diet advice, and they do. And, and then an example, and then licensure is nursing. It's a classic example of a license qualification because it's qualifications based, but everyone who's saying they're a nurse is mandated to be licensed. So 3 different ways that we do licensure as a group. And so some policy considerations around licensure of ultrasound technicians. There's only 4 other states that do it. New Hampshire just enacted it in 2018, New Mexico, North Dakota, and Oregon. Typically, we do a sunrise review on establishing a new licensure of a profession that's set out in Chapter 57. We really love that process because it makes sure that we're only regulating what we absolutely need to because we need to protect the public, and that we do it in the right way. The other piece is that we would strongly recommend that if there was a licensure program put over sonographers, that it be placed on everybody who's doing the work in the state and not just focused on one place, because that we see that as potentially legally risky for the state to do. Obviously relying on legislative council, but it should.
Well, part of your sunrise would be to understand what effect it would have should there be some kind of certification.
Yes.
Yeah.
And if it was a certification, then it would be voluntary. So I think what we're talking about, understanding what we're trying to get a handle on, would be a registration based on the national certification. And if it was a registration, then it would need to be for everybody in the state. So we would need to understand the effect of that registration for all types of medical practices, not just crisis pregnancy centers.
Okay, yes, that I would say.
So those are my high level points on those two questions that were posed to me.
Terrific. Can we get your testimony?
Yes, I just wasn't prepared to file it beforehand, but I can spruce it up.
This
and
is,
get it.
thank you. Yeah, go
That's a
ahead.
question. I'm wondering if you talk about the licensure of medical doctors who are apparently or claiming to be the medical directors of crisis pregnancy centers, and what do medical directors have to say who they are, and what would be the standards for that kind of position?
So currently my understanding is that sometimes it's very opaque who the medical director is. And I would recommend to this committee that if somebody is providing medical care in any form, that the patient is aware of who the provider is, even if the care is delegated. So when I go to my primary care provider, I know who my primary care provider is, even if I'm only seeing the nurse who's providing me a vaccine, or I'm talking on the phone with the nurse. I know who my provider is. I would recommend that, if possible, that opaqueness of the crisis pregnancy centers be eliminated. You know, that you're told who the medical director is when you are the patient, so that if you have a complaint about your care, you know how to direct it. And it provides an issue for us as an enforcement agency. You know, if we received a complaint about a nurse who was employed at a crisis pregnancy center, we would want to know who was the medical director of that crisis pregnancy center, so that we could understand the direction that the nurse was given, because there could be some mitigation on whether or not we should prosecute the nurse if he or she was given really bad
Direct
orders. And so we would want to know who the medical director is, and we would want to be able to ascertain that quickly and find that person.
And that's actually a good question to ask of Department of Health as well. Okay. Because when we're talking about the question about regulating the crisis pregnancy center, licensing it, and really when you talk about medical professions, the medical professionals, they're regulated through their professional organizations for best practice, and then whether through OPR or through Department of Health, through Board of Medical Practice and their various boards at OPR. So there is some oversight and regulation, but as you said, understanding who's the medical director at the center is critical. Pretty important.
And I'll just say, some of our professions have mandatory disclosures when you become a patient of a practice. So mental health is a model of that. Stem cells is another example of that, where the patient is given a disclosure statement saying what the qualifications are. You know, if I start a new therapy, a new therapeutic relationship with a therapist, I'm given a mandatory disclosure that tells me what the training is of my therapist and how to make a complaint about my therapist. And that's built into the law. And it's very protective because it assumes that that person is vulnerable and may need additional protection. So that could be another strategy utilized, but I would think that you would need to make it more universal and not just specific to crisis pregnancy centers to sustain legal scrutiny.
Any other questions? While we have her here, you're not going to be OPR for much longer, except when we need you.
Exactly. I'm always available, and I'll be here supporting the new person when he or she is identified. So
Thank you.
Yeah,
All
thank
right,
you very much.
Thanks for your testimony. Okay, this is helpful. I'm sure, we'll be picking up, we may be picking up additional testimony as we go forward, but we've heard a great deal about the bill, pro and con. And I wanted to ask, is Amarin or where are we in the discussion of the bill itself? David, were you here to testify or to be a phone a friend?
Whatever the chair needs. I think I would like to talk, maybe not right now, about other pieces of the bill,
Yes, please.
but I'm also here for these reasons.
Okay, so why don't we do that? Well, Alex will set you up to talk about do you have written testimony at this point? Or?
I do not have written testimony because I want to have a discussion with the committee to see what the committee is interested in.
Okay, that's good. We'll do that. And I know that Sarah has been involved in the discussion as well. So. Are you two going to sit at the table together to go through the bill with us again? What do we have?
So for the record, Amarin Daily Legislative Council. Last time the committee met on this bill, Jen and I walked through, I think it was draft 1.3, which is a markup of the strike all amendment for S37. Today you have another markup version of the bill, draft 2.1, which is posted to the website. This incorporates some of the changes that the committee requested in discussion last Friday. And then there are also some highlighted items where the committee wished to revisit some of the topics where the language has not changed from last Friday, but it was flagged for further discussion.
You come on up. And Jen, do you want to be together or how's that? Whichever way you want to do it. We have about 40 minutes, which is pretty good.
Sure, I'll continue. Grab that folding chair too.
We're going to have to restructure our room. So we are, I think we're almost at capacity. We are at capacity, this is it. Okay. All right, so you've given us a 2.1 draft and
Yes.
and you also have been working, because we've seen some information from you and others. Why don't you just take us through 2.1 and get us to the places where we need to make some more decisions?
We don't have hard copies of it, do we?
We don't yet, but Alex will get us hard copies of this tomorrow. You'll have it on your desk.
Sure.
I know, right on the old one. I think the old one is still good. The only difference I think between 2.1 and the new one, what? It's
There are
updated.
fairly significant, right, so.
There are significant changes, so I
Council, yes, there,
say
draft
suggest
2.1, I think in most cases incorporates the language that you
changes.
seem to be in favor of in the last draft and has new language highlighted or changes highlighted in yellow.
All right. So let's
If
go
that's
to
the
the
case
new
in
one.
my part, I won't do it.
I can print it. It takes a bit.
Oh,
Did you print one? Did you print it?
No, this is last week's version.
Okay, I'm gonna print right here, but it's gonna take an hour and a half.
Well,
Do you-
you
we
might want
can
to print it
send-
down the hall.
yeah, we
so-
can send a note to Tony and ask.
Why don't we do that?
Does everyone?
Yeah,
all the members of the committee want
I think
one?
everybody is enjoying the written copy.
I'll send it over to Tony.
Oh, you'll
Okay.
send it to Tony? Perfect. Thank you, Alex.
Do we want to wait for hard copies or should I?
Okay.
Or are we gonna start?
Did you want to wait for hard
We'll
copies?
take a 2-minute break.
Okay.
We're gonna go off live for 2 minutes, Alex, while we get the hard copies.
Roger that, taking us off